Just give me 1 second here, please. People against Miranda Rose Baldridge, 25B1494338. And if the victims are here, I would like them to step forward, please. Joshua Mutart.
There's a microphone right there inside of it. No, right there. You stand right there, you come on the podium.
Okay, come on up to the podium, ma'am. And Mr. Zayed, is your appearance? Mr. Zayed? I need your probation order, please.
Good morning, Your Honor.
Your appearance? That's great. Your appearance?
1051 on behalf of Ms. Baldridge. Who's at the podium. Justin Zayed on behalf of Ms. Baldridge, who's at the podium.
Your name, ma'am? Your name, sir?
Charter.
I want to read something, counsel, that I received. Have you had a chance to read the victim's impact statement?
No, Your Honor.
So I'm going to read it to you. Your Honor, and all members of the court, thank you for your time in this matter and for upholding law in Michigan. On October 3rd of this year, the litigant chose to place myself and my 2 children at risk to life and limb by proceeding into a turn lane for opposite direction traffic and pass us out of vengeance. She knowingly endangered the lives of numerous people on roadways and then proceeded to leave the scene of the accident. Her decision that day, guided by anger and emotional stability, have us here today. The litigant made a decision to deliberately crash into a car carrying 3 persons. The U.S. government places the value of human life at $12 million per life, so that in my vehicle, we were carrying $36 million in life had she killed us by her reckless maneuver. As of today, our car payment is $472.34 per month. I'm seeking $236.10 for the loss of our vehicle usage for 15 days of repairs that were required. In addition, I'm seeking loss of value to our vehicle in the amount of $2,000 according to numerous data sources, which I provided. In the state of Michigan, statute 2576.618 is a misdemeanor for property damages, which carries a penalty of up to 90 days in jail and or $100 fines, as well as loss of points and or loss of license. In my opinion, being the occupant and victim, along with my 2 children, the litigant lacks serious emotional control and decision-making skills. She could be held accountable for this aggressive maneuver. This needless event could have led to loss of life, not just of my vehicle's occupants, but simultaneously other persons in other vehicles. So I'm going to ask you what you have to say, and then I'm going to ask if your client has something to say, and then I'm going to come to Mr. Mutart and see if he has something else he would like to tell me, and we'll go from there. So I want you to understand, sir, the prosecutor agreed to dismiss the leave the scene, which is a 6-point violation, Mr. Mutart. Defendant pled to failure to report, and also as part of the plea agreement, it appears the improper lane use was dismissed as well as part of the plea agreement. So she's here for a failure to report. I'm going to explain restitution to you momentarily. I'm going to let you say whatever you'd like to say, Mr. Zayed.
Thank you very much, Your Honor, for the opportunity to speak. And again, thank you for the witness to appear today and provide that statement. I know that Ms. Baldridge certainly takes it extremely serious, and so do I. Your Honor, this was an accident, and accidents happen every single day. Ms. Baldridge takes responsibility for what happened after the accident. She should have remained there. She should have identified herself, and she should have reported the accident. She suffers from severe trauma, Your Honor. In the moment, she made an impulsive decision to take off and go home to her family, at which time it was too late to have reported the incident. Nevertheless, she understands how this could have affected the other individuals involved in the accident. But again, it was in fact an accident. She made a mistake. She's taking responsibility for it today. She accepted a misdemeanor for this crime. As it relates to the restitution, Your Honor, respectfully, that is the essence of the no-fault law in the state of Michigan, where both sides are responsible for the damage to their own vehicles. Now, if there are any other extraordinary damages that Ms. Baldridge could be responsible for, I don't think that she's skirting away from anything that could be tangentially related to her actions. But when it comes to the accident in and of itself and the damage that was caused by a traffic accident, we're respectfully requesting the court act in accordance to the Michigan no-fault law, where both sides are responsible for that with their own insurance. And I don't want to spend my elocution dealing with that technicality. I want to spend it taking accountability. And I know Ms. Baldridge wants to do the same. She has no record. She's not a criminal, Your Honor. She made an impulsive decision, and she understands how that affects other people. And this incident has certainly opened her eyes to that. I think that there's an extremely low risk of recidivism. I don't think that she presents as a danger to your community. And I think that you'll never see her again for this. And I certainly expect Ms. Baldridge to put this behind her and be a valuable member of our community.
Thank you. Ma'am, anything you would like to say?
Yeah, I just want to say that I didn't intentionally do it. It was an accident. I didn't make a false decision. And
Can you just keep your voice up for me a little bit, please?
it was an accident. I didn't do it on purpose. It wasn't a false decision, but it was an accident, and I didn't intentionally go into their car. I do apologize.
Mr. Mutart, is there anything else that you would like to say?
To me, being an accident would be using a passing lane and improperly judging the distance between two cars and smacking into the side of it. Using a turn lane for opposite direction traffic coming up eastbound from on Sibley Road and Highway 24. As we passed eastbound through the light, she used a turn lane for opposite direction traffic. She did
So she's on Sibley going
eastbound.
and she used,
A turn lane for opposite direction traffic
so for westbound Sibley traffic.
for westbound, it's for westbound traffic to turn south on 24.
I see.
So to me, an accident is improper passing, not judging distance correctly, but using a turn lane for opposite direction traffic, that being two solid yellow lines.
Anything else?
That was a turn lane. I did go on the turn lane, but it was a left turn lane because there's businesses on the left side there. It wasn't double line. But I did use the yellow lane.
Okay. Mr. Zayed, anything else?
No, Your Honor.
Anything else, Mr. Mutard? I want you to understand something, sir. I don't write laws. I'm going to make the laws. Mr. Zayed is entirely correct, and I'm not sure, and your lawyer, by the way, did a good job for you. I'm not sure every lawyer knows this, but if there is a criminal act that involves a leave the scene. So in other words, let's say somebody operated a motor vehicle while they're revoked and then left the scene. The act, a criminal act was involved in the accident. If somebody's driving and charged with reckless driving and the people can prove that, and then the defendant leaves the scene, that's a criminal act. If somebody is driving, again, like drunk, recklessly, or revoked, that's a criminal act that gave rise to the accident. Her leaving the scene, while criminal in and of itself, had nothing to do with this accident. So I don't write the laws, but my position has been clear from day one on this, going back 20 years at least, that there's no restitution available when the accident itself had no criminal element to it. Now, I suppose somebody could argue, well, but in the act of leaving the scene, they crashed my car a second time. That's different. This did not involve it. So I want you to understand, I cannot enter an award of restitution, and I will not do that. Ma'am, you need to be more careful. Okay? $100 fines. I'm not going to place you on probation. You got a clean record, but please use your head, okay? $100 fines, 300 costs, 75 victims' rights fee, $50 justice assessment. I'm going to order 12 hours of community service or 90 days. The community service has to be completed, hang on one second, by December the 23rd. Yes, now you raised your hand. Do you have a question?
I'm handicapped, does that involve?
You can do that at any nonprofit organization, sedentary work. I'm not ordering court work where you have to walk up and down the streets and pick up papers, okay? So it's 5 1/4 and 12 hours of community service by December 23 or 90 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that? Do you understand? I don't want you to walk out of here thinking the judge doesn't care that this person almost killed us, because that's not the case. I cannot order restitution when I know that restitution is not properly awarded in a case like this, okay?
Okay.
All right, ma'am, can you pay all of this today?
How much?
$525. I'm sorry? Okay, I'm gonna just indicate pay now. If you can't, you tell my court officer when you check your account, and then I'll be happy to give you more time to pay. You'll just walk back in here and we'll set up a payment plan. Counsel, that's it, except I'm gonna send you over to probation for they'll tell you where you can do, they'll give you ideas where you can do community service. Just has to be nonprofit, animal shelter, St. Vincent de Paul, Salvation Army, a church, I could care less. Okay, wish you well. Thank you, Mr. Zayed. You did a nice job here, sir. Thank you, Mr. Muhtard. I sincerely wish you well. I'm glad nothing more disastrous occurred here. Good luck. Thank you. Shanta Nicole Dawkins, 25I414933. All right, ma'am, your name?
Shante Dawkins.
Okay, so next time you have to call the court. If you don't have the money, set up a payment plan long before a show cause is issued, okay?
I think what happened is when I moved, I was thinking of like my mail and
Okay.
situations like that, so.
But you get my point, right? Okay, how much can you pay today? This is a show cause for failure to pay.
Well, really, I was trying to see if you can get the video because I actually wasn't speeding.
Well, you're too late for that, ma'am. You got the ticket back in July 7th. If you want to file a motion to set aside default, you can do that, but you're going to have to post a bond equivalent to this at 225, and you can't ignore a court like this. This is 4 months later we're talking about. Ma'am, they gave you the ticket, right? He handed you the ticket, right?
I can pay today if I need to, so I can get that for the day. That's all.
Okay, but I just want you to understand something. If you want to post a bond and file a motion to set aside default judgment, I'll be happy to entertain your motion. But I'm not likely to grant it. He gave you the ticket. You never called the court. You never said, I want a hearing. We sent you default notices. If you didn't change your address somehow, some way, I'm sorry to tell you that's your fault.
Even my check was wrapped up in the mail.
I can't hear you.
Even my check was wrapped up in the mail.
Your check.
Yes, everything was wrapped up in the situation with the post office. There was nothing that I could do.
Do you still live on this Rensselaer Street?
Yes, I was at Sharon Street initially.
We've sent, I didn't ask you that. I asked, do you still live on Rensselaer Street?
Yes.
Well, what do you mean you were there initially? You mean all these notices we sent
You
you?
notice that you guys gave me came with the old sticker on it. That means, that's what all the rest of my mail came. I wasn't reading it and had to go
Did
to.
you ever call the court?
No, I didn't, because I didn't get anything.
They gave you the ticket, right? The officer gave you the ticket, right?
Yes, I have a ticket.
Gave you the ticket July 7th. It said, I mean, if you want to fill out your motion, I don't have a problem.
Okay.
I'm just telling you, I'm not likely to grant it. Just not.
Just want out the video. How do I get the video to the situation?
You fill out your motion to set aside default. and I'll hear your motion.
I'm just trying to wonder, like, why would you say you wouldn't grant it if you want me to see?
Because it's been 4 months and you never responded to us. Lisa, would you please enunciate on here how many notices are sent before a show cause?
Yeah, let me bring it up real quick.
Not.
Ma'am, just let me finish. Just let me finish. Because I can't have people, go ahead.
We sent a default judgment on July 25th. We sent a 14-day notice, August 21st, a collection letter, September 19th, and then a show cause hearing on October 17th.
That's set for today, right?
That's set for today. Yep.
There's your answer. You still want to fill out a motion to set aside the default judgment? You feel free.
Yeah.
Ma'am,
That's over there.
Ma'am.
At that house.
Yep.
Everything else, like I said,
I cannot hear you. You got to keep your voice up for me.
the only paper that I have is the paper that I brought here. The other papers I do not have.
All those notices, we sent at least 3
I
or
haven't received a lot of my mail. I've been having situations. I can go to the mail, to the post office and get a letter if you need me to. I also have.
If you want to go post your bond
Yeah, that's fine.
and fill out your motion, you feel free. Lisa, give her a motion to set aside default judgment.
So what do I?
Ma'am, just listen, just listen, just listen. I'm going to explain it to you. You can go down the hall. You can post your $225 as a bond. And then you can fill out your motion. And I will look at it and I will decide whether or not to grant it or set it for a hearing. If I deny your motion, we're going to keep the $225. If I grant your motion or set it for hearing, you'll receive notice of that. Okay?
Can I ask a question? Where can I, it's on the,
You got to keep your voice up for me.
it's on the video for that day?
You would have to talk to the police. I don't know even, ma'am, if a video exists, ma'am, please, they don't give us videos. I don't know how we could store every video on every traffic ticket. We'd have to build a 10,000 square foot addition on here. Ma'am, you keep interrupting. I'm trying to explain to you nicely. You want to go to the police department and ask for the video, you feel free. Usually they don't preserve them for 4 months, but that's not my province. I have nothing to do with that. You feel free to fill out a motion to set aside the default judgment. And you post the bond, and then I'll proceed from there. If you want to go over to the Roseau Police Department and ask for the video, feel free. But I doubt they have it, but I don't know that. Okay? So you're gonna have to go down the hall, post your 225, fill out your motion, and I'll decide whether or not I'm gonna set it for him. Okay?
Thank you.
All right, good luck. US Ecology Transportation, 25B 149465 A and B. Who is the president here?
Jason Lewis,
You're the president of US Ecology?
the general manager acting on the authority of the president.
I'm gonna default you on all these. What's your name? What's your name?
Andrew Smith.
I told you guys I needed the president, whoever was here October the 16th.
Yeah, our president, like I said, we're a bigger corporation. It's hard to get them at our disposal.
I don't care. I don't know why people don't follow directions. Were you here on October 16th?
Just myself,
What did I tell you?
president or vice president.
Okay. Did you bring the president or vice president?
No.
Call in the prosecutor. I mean, I made it clear. Yeah, operations manager Smith appeared, adjourned 2 weeks to November 5th. Need president. I wrote on the other citation, need president. I'm not going to tell people 9 times what I think or what has to happen. So I have a good mind to default you on all of these. I probably am. And then we'll go from there. Okay, maybe you guys will learn a lesson. Why would you come here without the president?
I just spoke with my company. We just,
Okay, your name?
Caitlin Foley Park.
So I want to be clear on these civil and on a criminal misdemeanor, the corporation, if one's involved, has to have a lawyer. On a civil infraction, if there is no, technically, I suppose I probably should require a lawyer on all civil infractions too against a corporation. I try to bend the rule and say I need a president or vice president. These guys were here, Mr. Smith was, on October 16th. I told them I needed the president. Now they come in with no president, the general manager and the operations manager again. I'm not going to pre-try this again. So I'm going to enter a default judgment against them on both cases. And it's that simple. I don't know how many times I got to tell somebody. They come here without the president. They must have a lot of money. I'm sorry. I'm going to make a note. President failed to appear. Fines and costs on the misload are going to be $800. If they don't think it's important enough, I don't know what to tell them. On the commercial vehicle charge, $235. I'm entering a default judgment entered because officer failed to appear. Now, so you guys owe, or your company owes $1,035. I will give them until December the 5th to pay them. I keep having this happen and I don't understand it. They cannot send in operations managers and general managers. This is not the way it's going to work in here. Sorry, guys. Good luck. Maybe next time they'll show up. Nazir A. Chowdhury, file number 25B82624A, B, and C. Mr. Chowdhury, your name?
Jawad Chaudhry.
Okay, I'm sorry. I need Mr. Nazir Chowdhury in front of me.
Oh, okay. Let me get him 1 second. We did go to Brownstown.
Hang on. I need you to get him.
Okay.
Okay. I'm going to appoint a lawyer.
Hocam थोड़ी देर बैठ जाए सीधे.
Okay, sir,
Yes.
I have the note. I told you to appear in person. I'm good with you appearing by Zoom. I have this doctor's note.
Okay.
Can you please put Mr. Nazir Chowdhury in front of the camera?
He's not waking up. Well, let me finally woke up.
Well, he's going to have to wake up.
Okay.
Somebody's going to have to.
Okay.
I'm going
Okay.
to. Mr. Chowdhury, tell me your name, sir.
Nazir Chaudhry.
All right. I'm going to appoint you a lawyer. The lawyer is going to speak to you. And then they will handle the case. Okay. So we're going to appoint you a lawyer. You
Okay.
wait right there. We'll put you in a breakout room
Okay.
and we'll go from there. Okay.
Okay.
Thank you very much.
Thank you.
Darian Marquise Mex, 25B149358A and B. Good morning, sir. Your name? You're charged with driving while license expired and a stop sign violation. You have the right to a lawyer. If you want one, I'll give you one. Okay, I'll go ahead and arraign you. I'll explain your rights, the penalties, and then I'll enter a not guilty plea. And I'll let you go talk to the prosecutor. Fair enough?
Fair.
On October 13, 25 at 8:20 in the morning, it is alleged that you did operate a motor vehicle on Mills near Telegraph in Brownstown with an expired license. That is a misdemeanor. It is punishable by up to $100 fines, 90 days jail, costs of all those, and 2 points. Do you understand that?
Yes.
Stop sign's a 3-point civil infraction. You'd only get the higher the 2-point totals if you were somehow convicted of both. You understand that?
Yes.
Did you sign an advice of rights form here today and read it and understand it? If you plead guilty, you'll be giving up all those rights and there will not be a trial of any kind. You understand that?
Yes.
All right. You still wish to waive your right to a lawyer?
Yes.
I'm going to enter a not guilty plea. I'm going to give you a $100 personal bond. You don't have to post any money. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed, okay? So you'll go down the hall, or I'm sorry, right outside in the hallway. He's going to set you up. My court officer is with a lawyer.
Okay.
Okay, just be patient. They got a lot going, all right?
All right.
Thank you. People against Freeman Nicholas Chandler II, 25B149040B and A. Good morning, sir. Your name?
Segment.
All right, Mr. Chandler, you have a charge here of driving while suspended, revoked, denied. You also have a charge of disobey a traffic signal. You have the right to an attorney. If you want one, I will give you one. Would you like an attorney?
Yes, sir.
Presented by Ms. Hinkle. We have Mr. Harris from the prosecutor's office, Officer Evans from probation. We're here today for a final violation hearing. It's a preliminary matter with regard to jail time credit. We have 365 days of jail time credit on the case out. So, Mr. Harris, if you could do just on the violation, you could do just on the violation entry, just put that case is all time served. So we really only have the 22 case to deal with.
Correct.
Ms. Hinkle, does your client wish to have a contested hearing in this matter?
No, Your Honor, he would
Mr.
have.
Banks, do you understand the rights you're giving up by admitting to this violation?
Yes, sir.
Is this what you want to do?
Yes, sir.
Do you admit or do you deny that you violated probation?
I admit it, sir.
Based upon your admission, I find you have violated the terms of your supervision. We have 22 days of local jail time credit, 321 days of prison time credit. Mr. Harris, anything from the state?
Your Honor, the defendant's been given opportunities, obviously being judicially released, was put into a treatment program. My understanding is he completed CCC, but was at the Talbert House. There was a violation. There have been technical sanctions along the way. So technically, this is his second violation. This court has been very patient with the defendant, given him opportunities to play this to the best. I'm not sure why that hasn't happened. We don't believe he is amenable to community control. I think he's proved that through his actions. We would ask that the court reimpose his prison sentence.
Officer Evans, what's the recommendation from probation?
Yes, Your Honor. Since Mr. Banks is PV in August, he was given an opportunity to complete residential treatment with sober living. He did receive a technical sanction for meth use while in sober living. This second violation comes as a result of continued meth use while in sober living. I do believe that he does need treatment. However, his dishonesty and lack of accountability make it difficult to move in that direction. The recommendation is that community control is revoked and he does serve a period of time in prison.
Ms. Hinkle?
Thank you, Your Honor. After talking with my client, he has taken accountability for his meth use. He is very interested in still doing treatment. I would just ask that you possibly consider a CBCF as a STAR, or in the alternative, if not, if you could only consider a year of prison time.
Mr. Banks, what do you want to tell me?
Your Honor. I just wanted to say that I do appreciate any and every chance that you've given me. And I couldn't ask for a better PO than Miss Hillary Evans. I did try, like I said before, Your Honor. I seriously I'm tired of living this life. And if I'd have known where I've been going for the sober living, I would have never went there. Like I said, I should have spoke out to Miss Evans sooner, I guess, instead of just whatever. But I don't want you to think, like I said, Your Honor, I don't want you to think that I just tried to spit in the court's face or just said, whatever. It wasn't like that, Your Honor. It really wasn't. So if I understand you're going to send me to prison and I accept the responsibility, I do accept it. I admit to it.
Mr. Banks, usually I don't interrupt folks
Yes,
when they're doing that, but I don't want you to spend a lot of time on this, Mr. Banks, because I believe you. I do believe you that you want to do better, and I do not believe that this is in any way you disrespecting me or disrespecting Officer Evans. I don't take it personal, and I don't take it as that at all. So again, I apologize for interrupting you, but I don't take it that way. I just don't. I know that you don't want to be this person, but we're just trying to figure out how to balance that with also the crimes that you're committing. So go ahead, but you don't have to spend a lot of time on that.
I just, like I'm saying, Your Honor, if I could go, maybe possibly go. I understand I got a lot of time on the shelf still, probably a couple of years in prison still, but, you know, if I can maybe get a year and then I'll be out of your hair and I can just be done or whatever. I don't know, Your Honor. I understand I've got to pay for the consequences I made or the actions that I made. I do understand that. I don't know, maybe if you could just consider maybe a year for me, Your Honor. I don't know. I'm going to get in there and do whatever programs I got to do in prison.
All right, anything else I need to know about this?
No,
All
Your Honor.
right, so we are here really only now on the 22 case, which is a 36-month prison sentence that was served consecutively to the 12 months that you have already done. We have 343 days, so almost a year of jail time credit on that, which means you have 2 years left to do, Mr. Banks. I don't disagree with you again, that you need to do some prison time. You don't need to do the whole prison time, because to just give you your 36 months and jail time credit is a disservice to the efforts that you have made, even though we haven't succeeded and you were dishonest with Officer Evans a lot of the time. You kept at it, and it wouldn't be right for me not to give you some sort of recognition of that. So I'm going to impose a 24-month prison sentence. I'm going to give you credit for the 321 days of prison and the 22 days of jail, and a little bit over a year left to do. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they'll all be provided to you at no charge. Good luck to you when you get out, Mr. Banks.
Thank you, Your Honor.
All right, we're in recess.
All right, we'll set you up with a lawyer. You can go out in the hallway. Again, just be patient and we'll set you up, and then either way you're coming back in front of me, okay?
So about who be the lawyer?
Well, if you just told me you want a lawyer, so I'm going to appoint you. If you tell me, Judge, I don't want a lawyer, I'm going to waive my right to a lawyer, I'm going to arraign you. I'm going to explain the charges, the possible penalties, answer any questions on your rights, and then I'm going to send you to the township attorney to speak with you about a plea bargain. And then if they don't give you what you want, you can always fill out a petition for a court-appointed lawyer. I'm sorry?
Yeah.
So you don't want a lawyer?
So,
You do want a lawyer? Yes?
yes.
Okay. Well, out in the hallway, he's going to set you up with a lawyer, all right? And then either way, you're coming back in front of me. Joseph Raymond Height, 25B1494308, B and C. Morning, sir. Your name?
Morning. Just like,
You're charged with operating while intoxicated, open intox, and no ops, and you have the right to a lawyer.
I do have one. I have plenty for one. But he's not here today. So I don't need one, I guess. Or,
Okay, so you're going to hire one?
yes.
So you want me just to arraign you now and I can enter a not guilty plea and then you can bring in your lawyer next time? Is that what you're talking? Okay, so I'll go ahead and explain the charges to you, all right? On September 29 of 25, the police think at 9:12 PM that you were operating a motor vehicle on Valley near Oak Grove in Brownstown. They think you were intoxicated. That is a misdemeanor. It is punishable by up to 500 fines, 93 days jail, 360 hours community service court costs, or all of those. 6 points would be assessed on your traffic record. Your license would be suspended or revoked in accordance with your traffic record. Do you understand that?
Yes, sir.
And then on the other two charges, you're charged with open intoxicants. That's a misdemeanor, punishable by up to 100 fines, 90 days jail, costs, or all of those. Do you understand that?
Yes, sir.
And then the count 3 alleges a civil misdemeanor of no valid operator's license on your person, meaning you just didn't have it with you. That's a misdemeanor. That is punishable by up to 100 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, sir.
Did you sign the advice of rights? This advice of rights form.
Yes.
Did you read it and understand it?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. So I'm going to enter a not guilty plea. You can hire your lawyer. I'm going to give you a $500 personal bond. You don't have to post any money, but I'm going to set some bond conditions. And you're going to owe the people of Brownstown $500 if you violate any of these conditions. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. No contact with prosecution witnesses except through your lawyer, and you're not to purchase, possess, or consume alcohol, marijuana, or illegal drugs. Do you understand that?
Yes.
All right. So we'll give you a court date, and then you can go talk to your lawyer. You'll go down the hall, and we'll give you a notice. Okay.
Thank you, sir.
All right, lawyer Lisa, what do you have for me?
No, November 19th at 9:15.
Okay, November the 19th at 9:15 a.m. Okay?
All right.
Wish you well. Good luck.
Thank you. November 19th. 50 a.m.
No, at 9:15, I think.
9:15.
Yeah, and you're going to go down the hall. We're going to give you a printed notice.
Thank you very much.
All right, good luck.
Thank you.
All right. Waste Management, 25B149-753 A, B, and C. Mr. Powers, are you out there? Mr. Powers, need your appearance and you to unmute, please. There you go. Your
Sorry.
appearance.
Yes, good morning, Your Honor. Sean Powers on behalf of Defendant Waste Management of Michigan, P42752.
We have 3 charges, overweight, count 1. Defective equipment, count 3, and expired or exceed gross vehicle weight tab plate, count 2. You're going to plead to overweight. They're going to dismiss the 2 civil infractions. Is that right?
I think the B was a misdemeanor, but yes, the B and C will be dismissed.
Oh, you're correct. Yes, yes, yes. I usually get a separate jacket. You're absolutely right. That is a misdemeanor. So, but they're going to be dismissed, both B and C, and we're going to take your plea to count 1. You're authorized during that plea of overweight with agreed upon fines and costs of $5,000, correct?
Yes, Your Honor.
All right. To that charge of overweight, how do you plead? Responsible or not responsible?
Responsible, Your Honor.
All right. I'm going to accept the plea. Fines costs of $5,000. Paid by December the 5th. Okay. That's
Yes,
on
Your Honor.
file A. File C is dismissed. File B is dismissed. Yeah, that was my fault. So you're all
no worries.
set. Good
Okay,
luck.
thank
Thanks
you,
a
Your Honor.
lot.
Have a great day.
All right, now I'm ready. All right, can I have Lasha from each sides? Lasha Kutsides, 25B149-719, Ujadala. Oh, no, this is Mr. Jarboa. There you are. How you doing?
Hey, Judge, I miss you. I haven't seen you forever.
I know. You doing all right?
I'm doing well. It's been at least a couple of years since I've seen you.
Yeah, well, lucky you, right?
It is lucky me. Absolutely.
You're going to plead to, well, I meant not seeing me for 2 years. You're going to plead to distracted. They're going to give you a plea to distracted driving, and then they're going to dismiss the limited access, right?
Yes, sir, if you'll accept it.
All right, you're authorized to enter that plea on behalf of your client?
I do, Your Honor. Christopher Jarbo, P59507, appearing on behalf of the client with authority accepting responsibility.
Sorry about that. To the
No worries,
charge
sir.
of distracted driving, responsible or not responsible?
Responsible, sir.
All right, he's got a good record or not?
He has a great record, and he's got a CDL, he's a truck driver, so that's why we're trying to keep this off his record.
Yeah, tell him to slow down. He's going 98 though, okay?
I told him,
160, and I'll give him, and I'll accept the plea to distracted, dismiss the speed. 160 paid by November the 12th, all right?
160 distracted, November 12th. I got it.
Have a good day. Take care.
You too, Judge.
Thank
Good
you.
to see you.
You too. Tyrone Anthony DeShazer Jr., 25I-87413. Okay. Is he out there anywhere? No. Default judgments entered in favor of the plaintiff and against the defendant. All right, and that was scheduled for 9, and it's now 9:35. People against Clemens. Dominique Danshell Clemens, 25B149-562A, B, and C. Good morning, ma'am. How are you? Your name? You have 3 charges: driving on a suspend, revoked, denied, failure to stop with insured, that's a misdemeanor, and then failure to stop within the assured clear distance, which is a civil infraction, as well as no proof of insurance. Do you understand that? You have the right to a lawyer. You want a lawyer? You sure?
Yeah.
All right, I'll go ahead and arraign you, and then I'll let you go talk to the prosecutor. Fair enough? Yes? Okay. On October 14 at 25 at 12:38 p.m., it is alleged that you did operate a motor vehicle on northbound Allen or Pennsylvania and Brownstown. They think you had a suspended, revoked, or denied license, a misdemeanor punishable by up to 500 fines, 93 days jail, costs of all those 2 points. Do you understand that? You're charged with 2 other civil infractions: failure to stop, assured clear distance, which is a 2-pointer, and no proof of insurance, which is 0 points. Do you understand that?
Yes.
And did you sign, read, and understand this advice of rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
understand.
All right. You still wish to waive your right to a lawyer? I'm going to enter a not guilty plea, $500 personal bond. You don't have to post any money, but here's your bond conditions, and you're going to owe Brownstown $500 if you violate any of these. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You understand all that, ma'am? Okay. You are all set. Go out in the hallway. He'll bring this file to the prosecutor, and then you should be all set. Either way, you're coming back in front of me today, okay? Good luck. Do you have any of these, those? Just take it away.
First, case number 24, CR 42165. Present before the court is Mr. Reefers, right?
Mr. Reefers, Your Honor. Brandon Reefers, appearing pro se, and generally, not for the record, Your Honor, appearing generally. Sorry, appearing specially,
okay.
not generally, for the record.
All right, and we have Mr. Elter as standby counsel. We have Ms. Hyatt from the prosecutor's office and Officer Torek from probation. We are here today for sentencing. Ms. Reefers, did you have a chance to look at the PSI?
I'm sorry, sir?
Did you have a chance to look at the PSI?
I don't know what that is, Your Honor.
You know, I didn't think about this until just now, because usually it doesn't come up. Mr. Elter, did you have a chance to look at the pre-sentence investigation?
I spoke with probation regarding that, Your Honor. It gave some of the recommendations that he was thinking of.
Okay, where is it? Oh, okay. So, Ms. Reefers, we're going to let you read the PSI and then let Ms. Kuroko know when you're ready. I apologize that we should have gotten you that in advance. You're not allowed to retain a copy of it, but you can read it. Other than that, housekeeping matters, we have 1 day of jail time credit, and we have this is a mandatory community control case, right? We're all in agreement?
Yes.
And state opposition on the return of the firearms.
Your Honor, I'm assuming the defendant's going to be sentenced to community control, in which case he's not allowed to own or have access to firearms while he's on community control. So we would object to that until at least his community control until it's been terminated.
Is that a standard rule of probation, or is that?
Yes, Your Honor, it is a standard rule that clients under supervision are not permitted to own, purchase, possess, or use firearms, deadly weapons, ammunition, or dangerous ordnance.
All right. Mr. Reefers, do you want to go ahead and talk about the return of the firearms now, or?
I was going over the pre-sentence investigation.
Let's just take a break and let him go over the PSI.
Thank you, Your Honor.
Just let Ms. Karoko know when you're ready.
Thank you.
All right, we'll take a break. Sorry about.
I hate form though.
This is calling right.
You want me to do, who's Mason supposed to be?
He's overflowing for you and Hudson.
Lisa, I'm gonna leave it to you. If you want, since we don't have our court appointed, I could call these guys back in and give them another date. I hate for them to wait like that.
Well, we have an overflow here also. We can start using him until I get a hold of Durwood.
Okay, let's try that.
I'm
Thanks.
calling him right now.
Mr. Tio's here too. I don't know if that'll help. Smallwood, John Gregory Smallwood, 25B149428. Good morning, sir. Your name?
John Smallwood.
You're charged with operating while intoxicated. You have the right to a lawyer. If I'll be happy to give you one. Would you like one? Okay. So how about if I just go ahead and arraign you then, and then we'll set a court date and you can come back with your lawyer. You want me to do that?
Yes, please.
Okay. So on September 28 of 25, the police think you were operating a motor vehicle in the township of Brownstown on Fort near Gibraltar at 2:46 in the morning, and they think you were intoxicated. That is a misdemeanor, punishable by up to 500 fines, 93 days jail, 360 hours community service, court costs for all 6 points, license suspension or revocation in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. You understand that? Did you sign an advice of rights and read it and understand it?
I did. I understand.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that? All right. So I'll enter a not guilty plea. You're going to go hire your own lawyer, right?
Yes.
I'm going to enter a not guilty plea. I'm going to give you a $500 personal bond, okay? You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs, and no contact with prosecution witnesses. You've never had a drunk driving before, have you? Okay. So I want you to go over to Taylor, though, and take care of your civil infraction. You should pay that before you come back, okay? And then that's been outstanding since August of 24, all right? So you got to take care of that. And we'll give you a new court date. We'll give you a copy of your bond sheet. And then we'll give you a new pretrial date. And that will be on Is that the 19th, Lisa? Yeah, she's on the phone. I'm going to give you a court date of November 19th at 9:30 in the morning, okay? November 19th at 9:30 in the morning. You go down the hall. We will give you a paper notice, and then you'll come back, okay?
Sure.
We wish you well. Good luck.
Thanks, sir.
Okay. Priority Waste LLC, P5B 149-066.
Good morning, Your Honor. Alex Dillon on behalf of Priority Waste, P52648.
Can I ask you a question? Why am I getting so many of these adjournments here? This was adjourned. We had a court date set for the 22nd. It's a 9/5/93 ticket. And then I adjourned it to the 5th. Now you need another one. How come?
Well, Your Honor, I am standing in for Elizabeth Trombley. We are, quite frankly, trying to get caught up. We owe your court and others quite a bit of money, and it's we're just trying to buy time to.
Well, I don't want you to be doing that. Come on. I mean, negotiate the best you can, but if they don't start paying, I'm surprised it hasn't come to my attention. I'm going to start show causing them.
Yeah, well, I mean, we pay, and as much we were doing our best to stay current, but we have a lot of tickets in 6 different courts.
Can you pull this up here? I'm just saying that's different issue though, isn't it, Mr. Dillon? I find you and your colleague there to be easy to deal with,
yeah.
Right? I've never had an issue with you or her. But that's a different issue, time to pay as opposed to just kicking the can down the road. I mean, let me see what we got here. Yeah, you guys got some outstanding tickets for sure. I mean, I'm looking, let me see. Yeah, can you just move that? Thanks. My Lord, you got 30. Oh my gosh.
Yeah, I've been talking to your court administrator. I've been paying and working things out with them.
Call in Miss Foley Carter, will you? You tell listen, I don't want to be a hard guy, okay? If they're not asking me for time to pay on my cases.
View the PSI?
Yes, Your Honor.
Yes, Your Honor.
All right. Any corrections, issues, anything additional from the PSI?
There's a few things in there that I don't necessarily agree with, but just for skimming purposes, it's fine in their report.
Okay. All right. We have 1 day of jail time credit. We started to talk about the firearms. Mr. Reefers, what about that?
Your Honor, I think my paperwork kind of stands for itself. I would like the firearms to be returned. I have a statement, if it may, whenever the time's allotted.
I mean, we have 2 separate issues. We have the issue of the ownership of the firearms. You are entitled to the return of your firearms. So I'm going to grant the motion for you to return, for the firearms to be returned to you. We have a secondary issue as to whether or not you were allowed to have those firearms while you're on probation. We'll talk about that separate issue in a minute. All right, as a preliminary matter, we have the renewal of the motions to dismiss, the motion for acquittal. Court's already ruled on those, but I am going to deny the renewal of the motion to dismiss and the renewed motion for acquittal. Ms. Hyatt, on behalf of the state.
Your Honor, my understanding, I believe the recommendation, it is mandatory community control. You're talking about sentencing now, I'm assuming? Okay. We are asking, I believe the recommendation is community service, and as well as we're asking for corrective thinking. I'm trying to think of something that would maybe be beneficial for the defendant. But on the more punitive side, we are asking for some local time. He only has 1 day of jail time credit. So we're asking for at least 60 days local to be served. I don't know if he has a job. I don't know if you want to grant work release, but I just feel like some incarceration based on what his actions were that evening that the jury found him guilty of warrant that.
Officer Tork, anything from probation?
Nothing further.
Mr. Reefers?
Is now the time to make a statement, Your Honor?
Now's the time.
All right, Your Honor. This case began with one simple question. What are you stopping me for? I asked that calmly and never received an answer. From that moment forward, everything that followed spiraled because that one question was never answered. The record shows clearly, at 3 minutes and 2 seconds into the traffic stop, I stepped out of my vehicle and shut the door. By 3 minutes and 8 seconds, the deputy grabs my right arm. By 3 minutes, 12 seconds, he radios one resisting. By 3:14, by his own sworn testimony, that's when he considered me under arrest. In those 12 seconds, I was never told the reason for the stop, never advised I was detained, and never told what was being investigated. The prosecution even asked the deputy on the stand, did you tell him what the reason for the stop was before you cuffed him? He answered no. Even afterwards, when I asked, what did I obstruct? He said I prolonged his investigation. When I asked, did you tell me what you were investigating? He admitted, not at that moment, no. That's not lawful procedure. From there, I was tased twice. Then while standing, facing away with my hands up, he struck me with his ass baton. After I was cuffed, Deputy Simpson took my state trooper badge and credentials and put them in as evidence of guilt. What did that prove? That I know the law, that I served honorably? That act alone shows exactly how this case has been handled, by punishing knowledge instead of respecting it. At the jail, I requested a chemical test on camera, and the deputy refused. That denial is now part of the record. The jail intake video and audit logs from 1:30 to 4 a.m., which would verify that very request, are still missing. Civil counsel tried to quash the subpoenas, and this court denied that motion on September 8th. Yet those materials still haven't been produced. The record remains incomplete. In the crash report that supposedly justified the stop, there's no photos. One witness said white vehicle, another said black. The reporting deputy simply chose one color with no supporting evidence. No citation was ever issued. Even my address and driver's license number are wrong. That report isn't proof. It's an error sheet. So, Your Honor, I ask plainly, how can anyone be sentenced on a record this incomplete? Built on missing footage, contradictory witness accounts, and deputy's own admission that he never gave a lawful reason for the stop. I have met every obligation placed upon me. I have stood here in good faith, followed every order of this court, and done so with respect. All I ask in return is the same. Renew the motion, dismiss the case, or order a new trial, because this isn't about delay or defiance. It's about accountability. It's about an officer who abused his authority, answered a lawful question with force, and a citizen still standing before this court believing it will do what is right. May God's will be done. Thank you, Your Honor.
So here's the thing, Mr. Reefers, your entire presentation is based on a flawed premise. And that flawed premise is that if you're pulled over by a police officer, he or she has to answer your question about why it is that you were stopped. That is not the law. It is not the law in the state of Ohio. It is not the law in the United States of America. The Tepe v. Ohio, which is the quintessential case that involves investigatory stops, says you don't have to tell a person why they have been detained. That's the whole basis of an investigatory stop. I think that you know this, Mr. Reefers. I don't know, but I think that you do. In Ohio, case law is a little more nuanced, but it's still clear. Your question, why did you stop me, does not demand an answer. And your behavior following your not getting an answer was terrible. And first of all, with regard to the record being incomplete, this is the most complete record I have ever had in a criminal trial in the 20 years that I have been a judge. There is no stone that has been unturned in this case. There is no document that is out there that you have not had access to. Every piece of footage that we could find, some stuff wasn't saved, but also I would note that the jury agreed with you, Mr. Reefers, that the fact that you weren't given a chemical test or that you demanded one, all of the intoxication elements of this case were not considered by the jury, that you weren't found guilty of those. Everything that the jury found you guilty on is evident on that video, and your behavior should have been different. And I don't know whether or not you would have put up with the nonsense that you received when you were a law enforcement officer, and you just don't have the right to demand those sorts of explanations. And this is about your behavior, Mr. Reefers. You needed to be tased. You needed to be restrained because you were out of control. And it is apparent to me, having watched that video a couple of times, that you are the one that escalated this, not the deputy. And had you done the things that you were supposed to do, which is remain compliant and remain safe, none of this would have happened. You wouldn't have been found guilty of the obstruction. You wouldn't have been found guilty of the resisting. And this is on you. It is a mandatory community control case, so I am going to place you into my community control program. I'm going to do that on non-reporting probation for a period of 1 year. Because I don't think that I need to put that much work into you, Mr. Reefers. I think that you have generally had a law-abiding life, and I expect that to continue. I know that there was some discussion that you might go to Kentucky. You and Officer Torok need to have a discussion about that, because we have to transfer your supervision, even if it's non-reporting probation, to a different state. They don't have to honor our parts of the supervision. So I can put you on non-reporting probation, and I don't know a lot about ICOTS, but I do know this part. I could transfer your supervision down to Kentucky. They're going to make the decisions. They could make you report every week. They could make you drug tests. I don't have the ability to tell them how to supervise you. Usually it happens in reverse, that we send them a case and say, hey, this person needs more supervision. And they're like, no, we don't care about your Ohio case. But that's something that you need to discuss with Officer Torok if you're going to relocate outside the state of Ohio. If you're going to remain in the state of Ohio, then that's going to be your supervision requirement. In terms of special rules of probation or standard rules of probation, I want probation rule number 1, that you're going to obey the law. Probation rule number 2, that you're going to keep your officer informed about your residence. Number 3, that you are not to leave the state of Ohio without the permission of your officer. Number 5, that you are to obey all lawful orders given to you by your probation officer. And 8, that you are to report your arrest. The rest of the standard rules of probation, I don't want him on, because I don't want to put a lot of work into Mr. Reefers. It is a special term of your probation, Mr. Reefers, that you serve a term of jail of 90 days. I'm going to give you credit for the 1 day that you have already done. That means that you still owe me 89 days of jail. I will make you eligible for the litter pickup program, so if you want to go pick up trash on the crew, you can do that. You get credit against your jail days. You get an additional day of credit for every day that you pick up litter. So over the course of the 90 days, if you go out on the litter crew 20 days, you're going to get out 20 days sooner. I'm not going to impose a fine. I am going to impose the costs upon you. And we have the issue, there is no restitution, right? Correct. He owes a ton of money to community corrections for the monitor, but that's just one of those things. It's not a term of your probation that you are not to have firearms in your house. So as far as I'm concerned, when you are released from jail, you can go pick up your firearms, and I'll do an order that says that you can get them. So we have a couple of issues. Well, first of all, if you violate the terms of your supervision or you leave the state without permission, I can sentence you to up to the maximum penalty in this case, which is 12 months in prison, plus an optional period of post-release control of up to 2 years. That means if you violate, and if I send you to prison, the adult parole authority can, but is not required to supervise you for up to 2 years after your release. If they impose that supervision and you violate the terms, you can be returned to prison for up to 1/2 of my original sentence. Or if you violate by committing a new felony, then you can be returned to prison for up to 1 year, or the amount of time you have left on post-release control. It's automatically whichever of those is the longer period, and it's automatically consecutive to the sentence that you would receive for the new felony. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer, to obtain a transcript, or to pay the costs, those will all be provided to you at no charge. One of the things that you talked about in your filings, Mr. Reefers, was the fact that you are indigent. There's different tests for being indigent, and you sort of represented to me, I've never made a finding that you were indigent in this case because you were represented by Mr. Adams, who was retained counsel. When I appoint a standby counsel, I don't care whether you're indigent or not because it's not based on your inability to pay. But I assume that you're going to exercise your right to appeal. Am I right in that assumption?
Yes, Your Honor.
All right. Do you want to be appointed an attorney for the purposes of your appeal?
Yes, Your Honor. I requested to have the court appoint an appellate counsel on this.
Okay. This is not a standby, this is you wanting to be represented by an attorney for the appeal, right?
Yes, Your Honor.
All right. Are you working? Do you have a job? What's?
No, Your Honor, this has been my job doing this, and that's the part that I'm not clear on. You said the record is accurate, but I don't have returned subpoenas yet. And the crash report, with all the errors that it has, I don't have a complete record. I don't even have the original request that Paul Sarver read from the stand from November 24th, 25th area that the court said would provide me a copy of that. I haven't been provided any of that yet.
All right, Ms. Carrilco is going to give you the affidavit of indigency, which I know the black box one. Yes, that one. So that you can fill that out. And Mr. Elter, I think, is it okay? Would you be kind enough to go ahead and file the notice of appeal?
Sure.
That way, Mr. Reefers, you have 30 days from the date of the judgment entry of sentence to file an appeal as a matter of right. That judgment entry of sentence is going to be filed today. I don't want there to be any issues with the notice of appeal getting filed. So Mr. Elter is going to file that notice of appeal for you. He's not going to be your lawyer for the purposes of the appeal, although I guess he could. I don't know if you do that sort of work or want to be appointed. That's sort of a secondary issue.
I've done appeals, Your Honor.
Do you want to be appointed for the purposes of the appeal? Because you're the standby counsel, there's no ineffective assistance of counsel argument that can be made. I don't care. It doesn't matter to me. Why don't you talk to Ms. Idle, because I don't even think we do the appointment of that. So talk to Ms. Idle and she'll see.
I'll talk to Mr. Reefers and then talk to Ms. Idle.
Mr. Reefers, do you have a position in that?
I'm actually curious on the transcripts because the record itself is what contains the officer's statements where he testified he didn't give me any lawful reason of what he was doing or detaining me before force was used. That's the whole premise of the stop. I simply asked what was going on, and that's when he escalated.
All right, so as part of the transcript, once you are found to be indigent, which is going to happen today, and once the notice of appeal is filed, which is going to happen in the next couple of days, then Ms. Kilgore is going to start working on the transcript, and then you'll get a copy of the complete transcript of the proceedings. The other stuff we've already covered ad nauseum. I'm not going to go into that again. But
will that be all transcripts?
Yes, she will prepare a transcript of all of the pretrial hearings and all of the trial. Okay?
Thank you.
All right, I am going to remand you to the custody of the county sheriff, and good luck to you, Mr. Reefers.
and they're just, for whatever reason, not paying or ignoring, we're not going to get along. And I don't mean me and you. I mean me and the president of the corporation. I'm going to start show causing.
Right.
So I'm going to get Ms. Foley Carter in here. My Lord, you guys owe a ton of money. Okay, well, why don't we try to take care of this? Oh, boy. I don't even want to see that. That makes me sick. No wonder we can't keep the lights on here. Your name?
Caitlin Ford, Carter, Fresno Township.
I like Mr. Dillon. I really do. And I like Ms. Trombley, but I don't make decisions based on who I like or don't like. So I want to just kick these cans down the road here. There's no reason for it.
I understand that. I think we did come up with resolutions. I think he just needs to talk to his client prior to accepting that.
Well, how about if you talk to him today and I will give you 60 days to pay on this? I don't mind doing that if they're in trouble, but they got to start paying on these.
Yeah.
Maybe they should start complying with laws and not driving with, you guys are in here all the time. I mean, aren't they using their head? They got that kind of money where they can do that? I mean, why don't you guys try to resolve it today and I'll give him 60 days. If he's got to call his client and come back in half an hour, I'm fine with that. And then I'll give you 60 days, but tell them the judge is going to get impatient if they're not paying these within 30 days, okay?
All right.
Tell them to start complying with the law. My Lord, what kind of cases are, I mean, what are they doing over there? Don't they pay attention? They think they can drive with overweight vehicles and then, I mean, there's a ton of these. You guys are in here all the time. Let's try that, okay?
I mean, Judge, that's my biggest challenge. I mean, I tell them.
I know.
These are the violations. These are the
best
areas.
part about, you know what the difference between being a judge is and a lawyer?
What?
When you're a lawyer, your clients don't listen to you half the time. When you're a judge, the litigants don't listen to you half the time. So see if you guys can resolve this. He can call his client. He can zoom back in. I'll give him 60 days, but
yeah, we're focusing on your court, on paying your court. So thank you, Judge.
Thank you. So will you take this and you guys try to work it out? If he's got to call him, he's got to call him. But I wondered why all of a sudden these are getting adjourned like that. Okay, good enough, Mr.
Thanks, Judge.
You're a credit to the profession, Mr. Dillon. I appreciate having you here. You're always a gentleman. Thank you.
Thank you,
People
Judge.
against Ethan Lee Busby, 25B 149565, A and B. Your name, sir?
Ethan Busby.
You're charged with improper plate and no insurance. You have the right to a lawyer. If you want one, I'll give you one. I'm sorry?
No, sir.
All right. So on October, I'll arraign you and I'll let you go talk to the prosecutor. Fair enough?
Sir.
On October 16th, she's reasonable. On October 16 at 25 at 12:07 a.m., it is claimed that you're operating a motor vehicle on Inkster near Weston Brownstown with an improper plate. That is a misdemeanor. It is punishable by up to 100 fines, 90 days jail, costs are all those. You also have a second charge of civil infraction, no insurance. Do you understand that? Did you sign the advice of rights?
Yes, sir.
Did you read it and understand it?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
You still wish to waive your right to a lawyer?
Yes.
I'll enter a not guilty plea, $100 personal bond. You don't have to post any money. Here's your bond conditions. You cannot leave the state without consent. You cannot violate a law. Must appear in court as directed. We'll give the file to the prosecutor. You go out in the hall. She'll call you in and you see what you can resolve with her. If she doesn't give you what you want, you can come in and request a court-appointed lawyer. Okay? All right. Good luck. We don't have any, so you want to get off bench, we can. It's up to you. Okay. Did all you guys check in with my court officer?
I did, Your Honor. I was waiting to speak with Baldwin. I was sitting out there for like a little over an hour.
He's not coming in today. Do you have a pretrial? What's your name?
Nevin Janal, this is my last day here, so technically I already pled. So
He's got an 8:30 sentencing.
What's the charge again?
Failure to stand.
Not getting those sentences.
Don't know what happened to the sentencing.
Does Mr. Baldwin, Lisa, have another court date here? I mean, if Mr. Baldwin pled him, I mean, I guess it's just leave the scene unless there's a victim here. I think it might just be just as well to adjourn it.
I spoke with Marilyn and she's working on getting someone here. So we can use the overflow until then.
Okay. Okay, so just be patient. Do we have that fine? I never saw anything in there. Your name, ma'am?
Crystal Thomas, victim for Marlon Owens, sentencing at 8:30.
Jeez. You didn't get any of these. Crystal Owens, you're the victim?
Crystal Thomas, my son was the victim for Marlon Owens.
Your
We don't
name?
have any walk-ins, so I told John maybe check with the arraignment attorney also. See if she can help out.
I don't even have these sentencings. We got a Marlon Owens. Did I get is there a what's the charge on that one, Lisa? Can you tell me or?
Telephone harassment. There were 3 sentencings today.
I know, I didn't get any of them.
Well, we already did one.
I know, but it was just handed to me, but it was just a fair report. Let me check on these. Everybody stay seated, okay? Thank you. Sorry about this. Okay. All right.
Yes.
So we're going to give you probably November 19th. Is that going to give you enough time?
The only correction is to the employment. Mr. Owens is no longer employed at KBI. He's gonna be employed at, it's AISIN Employment. And he starts there on November 11th. But other than that, there are no other additions, deletions, or corrections.
Anything you would like to say on his behalf?
He does apologize for the situation, and we would ask that the court would adopt probation recommendations. Thank you.
Anything you'd like to say? Now, listen, you've been here twice. I want you to feel free to tell me whatever you'd like to say. And just relax and take a deep breath.
So, I would just like to say, thank you for Brownstone Police Station for taking your report seriously. I am thankful that due to the investigation, found that my son was not a target for anything worse. Unfortunately, your actions landed on my child's phone. There was many conversations with my child when I provided him with a cell phone about technology and the permanency of what you send out into the world. And about how he's responsible for that at his young age. Grown adults should know better. You should verify that information before it is sent out.
Your son is about to become 13, right?
He is.
Okay.
So it was a very upsetting situation. And then when you didn't show up for court, it made me feel that you were not apologetic, sympathetic, anything for your actions, and you didn't take it serious. I've had to miss time from work. This is my second time coming in. And I'm thankful for my job and their understanding the situation. But I just hope that you learn from this and take it seriously. Consider what you're sending out on that piece of technology and where it could end up in the consequences and repercussions of having somebody else.
Anything else?
No, that's it. So, Your Honor, the reason, and I know it's not an excuse, but the reason Mr. Owens didn't show up, he was working today, Judge. He understands it's not really an excuse. He does apologize for making the victim have to.
Did he call? Did he call? Oh, court. You left the state without consent. Did somebody tell you you could do that? Did I tell you you could do that? Why'd you do it? And why didn't you call?
I think I knew I had a job at,
I can't hear you.
we all knew I was working. I didn't know y'all didn't know it was
You think we got some kind of ability to foresee that somebody has to go out of work, has to go out of state for work? We just knew you were working and so should assume that you'd go out of state without calling us when you knew a victim was likely to appear, or even if a victim wasn't likely to appear. You wanted us to foresee that? You think that we have some crystal ball? You think that we're... I find this outrageous. Come here, look at me. I find this outrageous. I'm not talking about you not showing up. That's bad in and of itself, but that's minuscule compared to your conduct. You think this is funny? You think something about this is funny, sending these lewd videos to a 12-year-old? I'm not amused. And I'll let you in on a little secret. I got a really good sense of humor when I'm not in here.
Just for the record, it's clear it was in Marysville, Michigan.
I don't care if it was in Muskegon, Marquette, Tuscaloosa, Alabama, Key West, Paris, France. I don't care. I'm not, look, he's not the only one that doesn't show up. I don't understand people. I don't get it. I wasn't raised that way. I don't do that. But that's not the issue here. The issue here is his conduct. You send masturbation videos to a 12-year-old. Really? Really? Did he spend any time in jail in this? No. Right? You did or did not? I'm going to take into account the fact that this is really, other than the other offense that you had, theft or embezzlement several years ago. But I can't believe you just woke up one morning and decided you were going to start to do this. 12 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must report to probation as directed. You're to attend the impulse control program with Class A training center. You're to have a psychological evaluation and treatment if recommended. You're not to have any contact with the victim or the victim's family. Four days jail forthwith. Congratulations, you pushed me. 4 days court work program, $35 a day charge for that for 140. Jail term could have been a lot worse. I'm gonna assume you just somehow, some way had a brain freeze on this date back in September of 24. 100 fines, 200 costs, 75 victims' rights fee, $50 justice assessment, 3 1/4 screening fees, 60 for 385, probation fees are 240 for 625, attorney fees are 40 for 665, 805 including court work program fees. 4 days jail forthwith. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. I want you to give me a review hearing date, Lisa. If you show up and you do everything and you're compliant, I'll be happy to dismiss the case on motion to the prosecutor in 12 months. We'll give you that date now. It'll probably be in October of 26. What do you have, Lisa?
Can we double check the money? I got 905.
Sure. You're probably right. 300, 4 1/4, 485, 525, 765. You're right again. 905. Thank you. All right. Now,
October 21st for review date.
at 9 o'clock in the morning.
Yep.
So you're in custody for 4 days. Should be worse, really. I'm sorry. I probably should send him for more. I don't like this. Do you have all this to pay? How much do you have today?
I'll get paid till tomorrow.
Just tell me how, you don't have anything today?
No.
How much can you afford to pay weekly or bi-weekly?
They pay a couple of hundred.
I don't want you to, it says you're earning 500 a week. I know you're starting new employment. I don't want you to bankrupt yourself. You pay $100 bi-weekly. How's that? And I'll start that beginning on November the 24th. How's that? If you don't have the money on any occasion, you call the court, we'll go on Zoom. I'll be glad to give you an extension. Or you can come in here on or before the due date, 8:30. Just don't. You owe them an apology. You understand? Don't ever do this again. Good luck. Thank you.
Judge.
Nevin Todd Janal. Sir, you're going to have a seat over there. Thank you. 25B1477558.
Deanna Mateo, P8237A on behalf of Mr. Nevin Janelle. State your name for the court.
Nevin Janelle.
Boy, he says, I'm 74 years old in the victim statement. My encounter with this person was a meeting with the angriest, underlined angriest person I've ever met in my life, underlined exclamation point. What was this, road rage?
No, Your Honor. I just happened to sideswipe him. He was waving me to tell him my headlights were off. And then there was no really verbal interaction between the two of us.
Is there a John Zawacki here, either on Zoom, Lisa, or in person? He's asking for restitution. I don't know if you read this or not. It looks like he's not asking for it. He just said, that his insurance was going up because it's his third claim involved, and his premium's gone up over 90%. Third claim in 13 months. $2,700 damage to his vehicle. That's going to have to be done because, again, there was no criminal offense giving rise to the damage, so that's not the issue here. So I'm going to go ahead and sentence him, and we'll go from there. How's that?
Yes, Judge.
Anything you'd like to say in his behalf?
Judge, he's just apologetic for the situation. And we would just ask that the court take that into consideration.
Anything, sir?
No, Your Honor.
100 fines? How's his record? It's not too good either. Not horrible, but not good. $100 fines, 300 costs, 75 victims' rights fee, $50 justice assessment, 40 in attorney fees, 565, 2 days community service. That's to be completed by December the 20th or 90 days. Okay? 565 or 90 days.
Can he get a payment plan?
Sure. How much does he have today?
I have none today, but starting Friday, this week, I can do 100 a week.
Okay. $100 per week. I don't want you to have to rush over here. You start to pay that on Monday, which is November the 10th. If you ever need more time because something happens, you don't have the money, call the court, we'll go on Zoom. I'll be glad to give you an extension, okay?
Thank you, gentlemen.
Thanks very much. Probation will explain where you can do your community service at, okay? Naya Lene Thomas, 25B148943, A and B. Jeez. Good morning, ma'am. Your name? Did you meet, no, you haven't been arraigned yet, right?
No.
Okay. You have the right to a lawyer. You're charged with super drunk and open intox. You have the right to a lawyer. If you want one, I would be glad to give you one. Okay. So Lisa, what did we hear on the lawyers here?
We're using the arraignment and overflow, and Mr. Granata is on his way to help out.
Okay. So I will just give this to a lawyer and then just be patient, okay? Because it's, we had somebody not show up today, okay? All right, so go out in the hallway and you'll be set up with a lawyer. Wish you well. Good luck. Ethan Lee Busby, 25B149565A and B. All right, sir. Your name?
Ethan Busby?
You have a valid plate now?
Yes, sir.
And you showed her proof of that?
Yes, sir.
She's going to have you plead, or you've agreed to plead to the civil infraction of no registration, correct?
Yes, sir.
And then they're going to dismiss the improper plate, right?
Yes, sir.
And also, no insurance. You have insurance now?
Yes, sir.
That will be dismissed. To the charge, no registration. Responsible or not responsible?
Sorry.
To the charge of no registration, do you plead responsible or not responsible?
Responsible.
I'll accept the plea, 150, the improper plate's dismissed, no insurance is dismissed. Can you pay that now?
Yes,
Go
sir.
right down the hall, you're all set. Best of luck to you, thank you.
Thanks.
Okay, Kelly Nicole Whitehead, 24C21449. Good morning, ma'am. Are you Ms. Whitehead? No.
Me?
No, you're the victim, right?
No, I'm not, Your Honor. Good morning. My name is Carrie Miller. I'm the city attorney for the city of Wayne. How are you?
Thank you. I'm so sorry.
Okay.
Where is Kelly Whitehead, Lisa? Is she out there?
Judge, only Miss Miller showed up.
So let me just check something here. So I sentenced on this. The Judge O'Leary had recused herself. The state court administrator's office sent it over to me to handle. And
Yeah, the victim
I got this note from Shannon Straub of the probation department indicating that you had no objection to the early discharge. But I asked the prosecutors, especially when I've taken it under a statute, to come in. And I'm going to just ask you, are you willing to move to dismiss right now?
I am, Your Honor. Oftentimes I agree with you, and I think that they should serve out the entire time because of
I'm not even saying I say that, but when I said it under 771, even when they apply for early discharge, before I'm going to dismiss. So this is not new that I'm handling with you. I require the prosecutor to move to dismiss, or else they might be entitled to early discharge, but they're not entitled to an early dismissal. So
Understood.
Even though she hasn't shown up, and I'm always leery about dismissing when a defendant or a victim when a defendant hasn't shown up.
I'm not unbelievably comfortable dismissing without her actually being here to earn her dismissal. But I did speak with the victim. And so we are on the same page of allowing this to be discharged. And I would move to dismiss. I guess I would leave it up to how you feel about the fact that she's not here. I think, you're here, I'm here.
I know. I'm sorry for,
But she's eligible. The victim's not objecting. She's done absolutely everything that she was supposed to
and
do.
there's no other criminal charges pending, correct?
Nothing. And it was the recommendation of my probation officer to dismiss and take one off her caseload.
So you're going to move to dismiss.
I will, Judge.
She moved it. I'll just indicate you moved to dismiss. She's compliant. Case dismissed. Thank you. I'm sorry to have troubled you to bring you in here. Nice to see you.
Nice to see you too.
Sorry to accuse you of being the defendant there. Take care of yourself.
Nice to see you.
Have a good
Bye.
day. Sir, I am so sorry. What is your name again? Oh, yeah, I'm sorry. What are you here on? Do you have a case?
That's Brad, for Bradley Cosby. I'm the victim on the case.
Bradley who?
It's at 10 a.m.
Okay.
I don't know that he checked in.
Okay.
Retained attorney.
I'm sorry, Lisa.
He has a retained attorney.
Okay. So he has but they're not here yet, or he's not?
I don't know.
or
They would have went right to Caitlin, so they may not have checked in down there.
Let me just check it. Caitlin, I have Mr. Cole in here. There's a 10 o'clock where he's the victim, and I'm told there's a retained lawyer on that. Is the lawyer here yet?
He is not here. It is Mark Hart.
Okay. Okay.
I'll give him
All
a call,
right.
Judge.
Thanks. We'll give him a call. Thank you. Thanks, Lisa. Just tell him the victim's here if you would, please. You stay there and I'll be back as soon as they come in and there's something ready, okay? Thanks. Stay seated.
Assault with a deadly weapon, which carries with it up to 20 years in prison. It's an announcement.
Yeah, yes, sir. I really haven't had a chance to talk to her this morning. Can I get like 5 minutes?
Yeah, it's a year.
Yes, sir. I think we're probably going to put on the trial docket, but I'm going to confirm it with her.
Okay. Who is this LeVar Menifee?
Another person. Yeah, I get this.
That's great.
Yes, Your Honor. He lived at an apartment complex next door.
You don't have a romantic relationship with the man or anything?
Oh, no.
Okay, is he still around? You can't have any contact with him. Do you understand? Was he was he a street person? Or
No, Your Honor. Yes, that's correct.
Okay. Somebody sustained stab wounds.
My sister is.
You can find him with the question Facebook, social media. The rest to the end. We wish to file charges.
Yeah, I can. That's how the chance. Yeah.
Well, what's this? What's the name of this house?
Prince Hall. Is it
Prince Hall Apartments? You got stuff in. We got a trial in Port Arthur. Right now, stabbings. Just in the middle of that. Not good for this. Chamber of Commerce. Nonetheless, what state, do you have anything to say on this? It's an announcement. What do you?
No, Your Honor. I believe we've made an offer and shared the discovery.
Do you have a criminal history at all? State, does she have a criminal history at all?
I know she has another, let me check. She has another case in pendings.
You don't want to say anything. You might say something.
I don't see any right here. I don't see any.
Talk to him before you say anything when we're on the record. If you say something, it's in the records forever and you can't take it back.
Yeah, you're good. You're good.
Talk to him later.
They're having a conversation. You will not.
I'm looking to verify what his records show. How much?
I don't see any.
Nothing prior. There's not showing anything.
So she does have another pending, I think, misdemeanor assault case, but that's it.
For the same event?
No, sir.
Wait, is 2 weeks good?
Yes, sir.
We
said no good. We're going to research. We're going to get a research over here. Did you have?
Jackie Williams, I think is the way it's pronounced.
It is, and he may be in
Two cases.
for the misdemeanor.
Cause numbers 25 CR 151, 152, charged with attempt to take a weapon from an officer and assault on a public service peace officer.
Okay. Judge, I think we're going to put that on trial. I think.
Where is he? In custody?
He's in the county too. So he's got the misdemeanors. He wanted to check in because they were calling his names down there a second ago.
Who's the state on this one? Criminal history.
Nothing, I'll pretty defer, just got very little, he got some misdemeanor stuff, but nothing major.
Judge is here, he's in another court, they're going to get him now.
Thank you.
Think he wants an apology, and I'm not giving him.
We're settled for dismissal. You have to apologize.
Langston, you got something coming up?
I got Mr. Witz.
Probation.
Yeah, Mr. Witz. Open touch.
What's the name? Work.
I got Mr. Witz today.
Who? That man?
He's here.
Come on up.
Yeah.
He's an add-on.
Uh-oh, my leg.
Ryan West.
Yes, sir. He's present. He's here.
Uh-oh. What's going on here with Mr. West? Add on 25 CR 1157. Easy. What about it? What have you?
Here's a letter that you sent to Agumon right away. He removed his GPS device. It's a condition of his bond.
Right.
To get him here paid for.
You might.
Where is the GPS device?
It's for John. That's what I decided.
It's what?
For John. Seriously.
The people I had got the GPS tracker from, I wasn't paying on it. I missed.
You gotta have it or you go to jail.
Yes, sir. I understand.
Yeah.
Well, you don't have it?
No.
You aren't going to jail.
But they said I could get it put back on. And I couldn't.
Well, I'm not waiting on you to do that.
Well, no, so you don't gotta wait. I mean, I could.
No. You're supposed to have a GPS device.
Yes, sir.
At the most soon time possible.
Yes, sir.
When did they tell you you could go and get it?
I believe it was Monday.
Oh yeah, you should have had it Monday.
But they had.
Look, I don't make a deal with you. You're going to have to follow the directions.
Yes, I know.
Right now, because of your situation being a transient, sorry, we got to know where you are all the time.
Yes, I know.
There's 7 billion people on the planet. We're not going to go find you when you don't show up.
Yes, sir. But it's like
I ordered a GPS device. You don't have it. You sit over in the bad spot. Sorry.
They got called me and said
you should have paid them. So that's your problem with them. You got to deal with them, not me. I'm not making deals with you. I'm giving the orders.
I understand, but I'm waiting for my dad.
If you understand, then you know how it works. You sit in jail until you get a GPS device. I'm not going to let you venture out. You're going to speak over me, Mr. Rude? She's got to take everything down, the court reporter, when we're both speaking over each other. She can't take it down. And then we all get in trouble who is speaking over each other. Don't do that. When I speak, stop and you get a fair opportunity to speak. I ordered a GPS device. You don't have it. You're violating an order of the court. You can be held in contempt of court and I'll revoke your bond and you will have to sit this out until you can obey the court orders. But everybody has to follow.
I can't put it back on.
Yeah, you should have never taken it off in the first place.
Well, they had came and took it.
That's your mistake, not theirs.
How's that my mistake?
You didn't pay them.
They called me and told me to take it off.
You didn't pay them, right?
Yeah, but I'm waiting.
Sorry, that's the problem. You've got to figure it out. It's like we all do when we have financial issues.
Yes, sir.
Sorry, I ordered a GPS device.
Yes, sir.
Now they can come and get one brought in here in jail, but until you get it on you, I'm not going to release you because I ordered this for a good reason, sir.
I understand.
I mean, these.
doing a fully environmental, if you feel it on the trial, that's what.
Just on point, I can't afford it.
School, but at least she can.
I got a court appointed attorney.
I know, but the grand jury indicted you for a felony offense of theft. And it states that you were burglarizing automobiles in Port Neches at 3:49 in the morning when they caught you. Whose fault might that be? Don't say anything. I don't want you to say anything. I'm just asking you rhetorically. So don't make us feel bad that you can't get a, but you can see when you're out and about at 3:40 in the morning, allegedly burglarizing and vehicles in Port Neches, and you are a transient, then we've got to have a way of making sure we know where you are. And when you don't pay, you lose some of these freedoms.
I can't pay this.
He has failed to keep his court-ordered GPS monitor on. He does not check in every week.
Yeah, her spot.
Yeah. All right. Your bond is revoked. You were taken into custody. You need a copy of this. It shows the reasons that they just didn't do it for failing to pay. He didn't check in regularly as well. Here, make a copy for Langston, please.
Well, thank you.
Until he can get the GPS and all the rules, he's in custody. What are we going to do?
I think I'm going to take these.
See what you can do about it. Okay.
Let me see if I can do it right.
Thank you.
I'll email it over to you. Once I
I don't know if you do it. Let me see if I can do enough to link.
Okay.
Please. Hey. You fired the block.
Hey, Ken?
Yeah. That's supposed to say that.
Yes, yeah. Talk to them.
No, I already got.
Oh, okay.
We're gonna sign up right now.
All right.
I'm gonna move it right now. But I need them.
John West. John, is this true? Lisa Kalla, a defendant, has passed?
That's what I'm talking about. You're saying you and Lacey. We don't have proof of it yet. We have no reason to doubt it.
Okay, until, well, we can't just verify that we do anything.
That's what we're going to do. We're just going to pass it for a few weeks for us to get verification.
See, what we had yesterday was a notification for the bondsman based upon someone else telling them.
Right.
And it's apparently being dealt with in Louisiana, which may be hard to get some information. But until then,
yes, you should.
did the state send a motion to dismiss?
No, not yet. No.
Okay.
No. We're not doing that until we get proof. And
Okay.
we need to get documentation of that.
All right.
We don't have to.
Well, let me review in a week.
Yeah.
Just to be on the safe side. Mariah Howard.
Yeah, that's going to be a plea.
Is it ready?
I sent it to the.
Okay.
I don't know.
Is Mariah in custody?
We don't have it.
Mariah.
She's got a small child with her, so she tries not to keep.
Okay.
Whenever you get ready, she's here and ready to do it.
Business. Mr. Williams, Chair Judge.
Come on up.
I just got out, I guess. Did you first? Yeah, I got her.
That you okay?
Yes, sir.
Okay, Jack Williams, one of those 25 CR 151 152 attempting, state jail felony of attempting to take a weapon from a peace officer in 152 is the second of assault on a peace officer. You were looking at up to 2 years in the state jail on this attempt to take a weapon from an officer on 152, the second degree felony of assault. Carries with it up to 20 years in prison, which once you get over 10 years, you can't get probation. And we got an assault.
Certain case.
Yeah, it was, is what is alleged here. So these are two serious offenses. Now, today, what's that?
Judge, seeing as how all the case is, probably need to put it on trial, not give the court doesn't give us no more announcement. We're probably gonna have to try it.
Okay. What's his bond right now?
Williams.
Yeah, Jackie. You still at 3395?
Yes, sir.
Okay.
5,000 for the 050159.
And stay on this. Who's that's your, what did you say?
On the 0152.
Oh, criminal history, if any. Have you lived in Jefferson County your whole life?
Yes, sir.
Shall we hang on? Are you appointed? Yes, sir. He doesn't have a indigent form. I see one affidavit here now.
Years probation on resisting arrest.
When was that?
So you figured to identify us back in 2024, looks like.
When?
June.
Is he allegedly committed?
This is December, isn't it?
Yeah, in December. December 8th, 24.
No.
What else does it show?
That's it. Figured ID in the resisting arrest.
Is it a deferred or regular?
It just says it's a probation substance deferred.
Is it misdemeanor? You said?
It's resisting.
Yep.
Ma'am?
It's clear.
Yeah. The figured ID and a resisting all the same.
How long did you stay in jail?
I didn't have a week. I bonded out.
No, you didn't. Not that. You wouldn't bond out from a sentence.
I don't know.
Yeah, he must be thinking
You talking about this one?
He's probably thinking about this.
Oh, yeah.
No, I'm talking about those two that we're talking about, those misdemeanors. How long? Do you remember how long you
No,
saw?
I was home, well, basically.
No, yes.
You never went to jail?
No, sir, I was probation. The
Did you serve any time? When you arrested, you went to jail?
Well, how long is your probation?
when I was first arrested, it was
How long is your probation?
Well, it was for a year. It's supposed to have been expired by now.
No, I don't think there could no.
I'm gonna look and see if there's a motion. What we do?
Well,
It's the failure to ID. Looks like it has an MTRP, and then there's two newer ones.
Those are probably related to this case.
but when was he put on probation? Because if he's put on probation for a year,
I can grab if I can see.
this was indicted in February, which alleges a December 8th to December 8th events.
Reads MTRP was done December 24th, 24. He had court today.
Hold on. He was placed on probation when?
It looks like 12/24/24.
No,
Weird.
that's when he got this off then. So he was placed on
Okay.
probation.
They did an MTRP poll.
Yeah. The probation was back in June of 2024.
Okay, all right.
They reopened
So
it.
he was on probation when he allegedly committed these two. And you said there's a motion filed?
Yes, there is.
Okay.
Misdemeanor.
Did you know that, Brent? You gotta look
Also,
at
there's
that.
also a motion filed.
Okay, so there are motions too. You should have been summoned for that too. There's gotta be a warrant out for you for that.
No, I think his court date was set.
That.
Yeah, he's been going to misdemeanor court too. He's been appearing in every one of his court dates.
What's going on in that?
Sure.
Who's your lawyer over there?
I don't have a lawyer.
You representing yourself?
No, sir, I just haven't been over there. I just been coming here because they
They
put
haven't
them on the
appointed
same
him,
day.
you know. That's why I was.
Okay, so you've got two sets of fires. You've got the probation that you're on. And then these.
Yes, sir.
The problem is that you were court ordered to follow terms and conditions of probation. And the very first one is don't commit a crime. Yes, sir. That's the very first one, and this is probable cause that you did, which puts us in a bad spot. You were on bond here. You placed on bond, but you had a history, a criminal history that you were on probation for, and they filed a motion to revoke probation. Yes, sir. You got some fires that are problematic.
I tell myself being fit.
And Judge, he has been very involved in that. Good communications with he and his family on this.
I'm not worried about his communications with his family. I'm more worried about the community and crimes being committed. You got 4 crimes here, right? You were on 2 probations?
No, I was on no probation.
For what?
For the resisting arrest and failure to identify.
That's 2 offenses.
So yes, sir.
You were serving 2 probations for 2 crimes, but that's the same time.
Okay. Yeah.
1, 2. 2 things. They don't package them together like that. Those are 2 separate offenses you're on probation for. Now you got these 2 felonies. One of them is a second-degree felony that allegedly you committed. And when were you put on probation again?
Last June.
June 24? Yeah. So after he was on probation. So that's an issue. I mean, you have, that's enough to revoke your probation or for the underlying offenses, but you just don't get treated on the new cases with bonds that are not answerable to the fact that you were on community supervision and court supervision for 2 other offenses when it's alleged that these are more serious offenses. All right. What's his bonds?
It was 5,000 for one and then 10,000 for the other.
I guess 5 for the state jail felony and 10.
No, 0151.
151 and 152. All right. That's right. Fate, anything to say? No. I'm going to raise his bond. I'm doubling his bonds on each of these new cases. Sorry, but you were on probation. Court ordered probation and supervision when it is alleged that you committed these new offenses. And number 1, on all bond conditions, don't commit an offense.
Mike, are the revocation, is the MTR on distant cases alone, or is there something else?
No, so those 2 cases, not these cases, but 2 that he was on with.
Yeah, but I mean, it's not like failure to report or anything else of that nature.
Let me look.
So I mean, if it's just these 2 cases.
What do you say?
I think we had probation for
Yeah,
2
it's straight. Well, she's saying
misdemeanors
4.
and then 2 new felonies.
That's what I understand.
So there's 2 MTRPs with 2 new misdemeanor cases.
He was on probation for a few months when it's alleged he commits these new offenses that the grand jury is just indicting. Well, he just can't sashay out of here without being answerable for.
Judge, he's been here every time.
That's criminal history, and
But just
part of the
point
equation.
of bond is to him promised to be here. And he's been
Anything else you
showing up
want to
every
say?
time.
His bonds are, I'm going to treat him like I do everybody else. Like this, your bonds are double. And you have to have a GPS device so we know where you are when you're if you're committing crimes. But that's normal and customary.
Yes.
We'll do this for every one of them, but on my watch, you're going to go and we'll sell it. If you're on probation, I'm answerable to the people. I go, what the heck? We're supposed to have a safe community. You're on probation, and then now it's alleged you're committing more serious crimes.
Same time.
Right. Well, that's the order report. What's the next event? Put it for trial?
Yes, sir.
All right, it's 7 trial. Giles, yes, Christopher, Broughton.
He's present.
Excuse me. Yes, just revoked his bonds for these new offenses. He was on bonds on the others.
Actually, I don't know if they were shows, so.
Or he was on probation on the others, but his bonds are revoked on these for committing these offenses while he was on community supervision, and now it's been indicted. On Christopher Brown, 25 CR 721. Okay, going in. That's you? What are you going to do today?
Your.
It's indicted in June.
Yes.
Sir, this is a second degree felony, aggravated assault with a deadly weapon, which carries with it up to 20 years in prison. Serious. Are you still at 6650? Yes, sir.
No, sir. I'm at they can say,
Hold on, just a second. That's
I guess, yeah, that's why we're.
I'm so sorry. I didn't have no babysitter this morning.
I
but
understand.
didn't
It's just,
play-
it's just sad. You know, the child shouldn't be,
I know.
some of it's are its memories. It's just an infant. I know. It's too bad. I just don't want a child to see the, in this circumstance, you know, that's just a sad thing. Boy, is this something you can fix?
It's probation, Your Honor.
I don't know. Can you fix this and do better? Man?
Yes,
Because this child is,
I'm currently going, I'm sorry, I'm currently in school and working also. Everything is.
But you're here not because of just this one event. How many, I'm looking at paragraph 2, 2 or more prior theft convictions result in subsequently, if you steal a pack of gum,
Yes, sir.
it's a felony the rest of your life, a felony.
Yes, sir.
How many prior convictions of thefts do you have? Don't tell her,
I don't even know.
Probably like 6.
ma'am.
Like 6.
6, 8.
8. Yes, sir.
I'm a stranger to you. I know more about your criminal history than you do. I should not be, you know, because it's too many. These are all thefts, Angelina County, Jefferson County, Harris County. My gosh,
Yeah.
do not steal.
I know I'm done with that life. I'm trying to live my life around.
What caused all of this? What? I mean, you've got role modeling right here that you have to show and do. My gosh. God, what's what's the best gift you give to your child? What's the greatest gift you give to them? Good example. Because the child is going to do just what the parent does.
Yes.
They're going to emulate the parent because that's their natural role model. Nature does that to us. My parents, I role model after mine. All of us. Well, you know what your child
Yes.
role modeling. You don't want to role model in the worst way.
I know you.
Fix this. This is dishonesty. Thou shalt not steal. It's in the good book. It's in the penal code. So it's not like we're ignorant about what our requirements are. Live honest. Harm no one. Give each person respect.
Yes, sir.
In 24 CR 1004, does the defendant Mariah Nicole Howard waive a formal reading of the indictment and arraignment? Can we proceed in summary?
No, because we're pleading in the other case, Your Honor. That's the one that my list says.
Supposed to be on, 500 restitution. Chronological sequence. We're jumping to chronological step. All right, 25 CR 1350. You were Mariah Nicole Howard. This one.
Yes, Your Honor. That's the one.
All right. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in the summary in this case?
Yes, Your Honor. Can.
In this one, ma'am, paragraph 1 alleges that on or about July 31st of this year, 2025, in Jefferson County, Texas, you committed theft. It looks like clothes. And paragraph 2 goes on to allege that you have 8 prior theft convictions out of Harris County, Angelina County. Is paragraph, or these allegations in paragraphs 1, and these are convictions of crimes. Are these allegations in paragraphs 1 and 2 all true and correct?
Yes, sir.
And are you guilty of these allegations in each paragraph?
Yes, sir.
These are state jail felonies. This is a state jail felony, rather. And it means convicted, you face no less than 180 days up to 2 years in the state jail. And a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement has been reached. Was that you, John, or the judge?
Hey, I've been known to make those sounds.
Oh, okay.
Yeah, after a couple of days of trial, that's what I start sounding like.
An agreement has been reached where you would be pleading guilty, sentenced to 2 years in the, this can't be right, the system's confinement in the county jail.
But I put in the wrong one, I
A
think.
misdemeanor thing.
No. It should be 2 years in state jail. I just put it on the wrong spot.
Okay.
Yes, you get 2 years state jail, probated over 5.
You would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years. You would, there would be terms and conditions of probation, which are normal and customary for this type of offense. You must pay restitution back in the amount of $161.20. The quicker you pay that back, the quicker this gets dismissed.
Can I pay you today?
Talking, they've got to set up the file, but the quicker you pay it, the quicker I'll dismiss this, as long as you follow the other terms and conditions of probation. First of all, it's don't commit a crime. It's time. You that role modeling for the child. So how do you plead to this charge? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, which alleges these prior convictions, or all of those prior convictions alleged in paragraph true and correct. And are you pleading true and correct to paragraph 2, the prior convictions voluntarily and because those allegations are indeed true?
Yes, sir.
I show you the Mark the State's Exhibit 1, Jonathan. Thank you. Did you sign that document?
Yes.
Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes.
State's Exhibit 1 tendered.
No objection.
And evidence without objection. John, hold it down there. The lawyers get excited when I do this colloquy here.
I know I do.
Among other things. So State's Exhibit 1 is made a part of the record for all purposes. Otherwise, this court is going with the findings that you are mentally competent to enter your guilty plea.
Yes, sir.
You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of the state jail felony of theft. I am following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. That confinement will be suspended, be placed on regular probation for 5 years. We can shorten it if you do well to a third of that. Please note, among other conditions of probation, there'll be a theft class that you'll have to take, but also you have to pay back restitution to stand by to the victim in this case in the amount of $161.20. And this is going to be Carter's Babies and Kids in Beaumont to the people and it looks like Fonzie Jones is the owner of that anything. Make sure you follow those terms and conditions here that the probation is going to go over with you. If you fail, your probation could be revoked, and then you could be sentenced up to 2 years in the state jail. And who's going to take care of your dependent? This is you've got responsibilities, not to yourself anymore, but to the child as well. The father, how's the father doing? Is he responsible and taking care of things? He's incarcerated. Yeah. For what?
Aggravated.
What was the sentence?
8 years.
He's going to have to serve half of it, or he can be paroled. All right. The other case has been dismissed in this 24 CR. Stop computer 111004. That case is dismissed. Okay, sign. Papers. All right. Please see the probation officer. Thank you.
First meeting first.
Oh, yeah, gotta take a couple. Here's Miss Howard. I have Brian West.
I'm ready whenever you want.
It's to you. Great.
We just need to get him on.
And we just need to.
Yes, sir.
Dennis, we need to tell the jury that we're going to need about 15 or 20 more minutes and thank them for their patience.
And we have 2 more to make.
Brian West.
No, right, but it's the other one. One more.
He's coming, Judge.
We don't trust it. Thank you.
Brian West.
You.
I think we did. I don't see it. I didn't eat it, I don't remember. I would have remembered. There we go. Brian West. You need to see her first, right? You got it. 25 CR 1157 is called. Here with Brian Cannon West, here with your attorney, Mr. Adams, and the state's attorney, Dust. The defendant waive a formal reading of the indictment and arraignment. Can we proceed in summary?
Yes, sir.
In summary, this states that on or about July 28th, 2025 in Jaffers County, Texas, you committed the state jail felony of theft of a firearm. You understand what you're charged with here, sir? If convicted, you face confinement in the state jail for any term of not less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand the punishment range here? An agreement's been reached where you would be pleading guilty, but not found guilty, placed on deferred or unadjudicated probation for up to 5 years. You're going to be given a second chance to fix all of this. Can you do that? It's good.
On my head.
That sounds like. Restitution is to be paid back in the amount of $500 to the complainant listed in this indictment. When can you get that paid back?
I'll say by the end of this month.
I'm gonna give you 2 months, 60 days, okay? Can you do it? All right. If I follow this agreement, you have no right of appeal. Do you understand? How do you plead to this, sir, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is. I don't know what's wrong here. Here, this pad is stuck now. When we're gonna get something in this newspapers.
Yeah.
Kind of open up sounds.
That was weird.
New maps.
How do you plead to this, sir? Guilty or not guilty? I'm sorry.
So
How do you plead? Guilty or not guilty to this charge? Are you pleading guilty voluntarily and because you are guilty? I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your, or the contents all true and correct? State's Exhibit 1 tendered into evidence without objection. This states you are mentally competent to enter your guilty plea. It's really involuntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Every sentence report is waived.
Yes, sir.
I'm going to follow this agreement and find, sir, you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty of this felony offense, but I'm not going to do it. I'm going to defer any finding of guilt right now. Place you on deferred or unadjudicated probation, give you a second chance. Make the most of it. There will be terms and conditions of probation, which are normal and customary for this type of offense. Follow them. If you fail, your probation can be revoked. You can then be found guilty of this felony and sentenced up to 2 years in the state jail. If you do well, it will be dismissed, and we can do it as early as 1/3 of 5 years, which is like a little over a year and a half. Do well. Okay? See the probation officer. Thank you, sir. Oh, and restitution is owed and to be paid in $500 to the complainant, and get that done in 60 days through the probation office. Here's this. Thank you. Here's this. All right. Hold on. Let's get ready for trial.
I'm gonna go make those changes. I'll bring it in. Okay.
Thank you.